This is the CitizenLink Report.
If you find our insights helpful, would you support our video efforts? Your gift of $25 or more goes a long ways. Covers the crew, lights, cameras, all that. Just click on Donate. Thanks from all of us.
A big win for the First Amendment at the Supreme Court. A pro-life group will have its case heard. This is the CitizenLink Report. Hi, I'm Kim Troby, along with Bruce Houseconnect, legal analyst for Focus on the Family, who joins me today. Hey, Bruce.
Hi, Kim.
Always good to have you here. So you and Stuart Shepard talked about this case several months ago. The Susan B. Anthony list was arguing their case before the Supreme Court. Tell me a little bit first about what SBA does.
Well, SBA list stands for Susan B. Anthony, and it is a pro-life organization that educates and promotes those kind of policies, and it gets involved in elections through educating voters about the political stances and political records of candidates. And that's how they got involved in this particular case.
Now, SBA List wanted to put up billboards during an election, and what they were trying to do was point out Representative Steve Driehaus's stand on abortion. Talk a little bit about Driehaus's record and what happened with the billboards.
Well, you'll remember in 2010, Obamacare was passed and signed into law in March, and that November was a big election, especially in the House of Representatives. And Driehaus was a congressman from Ohio. SBA List got involved during the latter weeks of that campaign. They wanted to put up a billboard that residents of Ohio in his district would notice that said his vote for Obamacare was a vote for taxpayer-funded abortion, because as we got to know about Obamacare, we realized there are several subsidies and indirect ways that taxpayer money gets funneled to people who are paying or providing for abortion.
Now, you and I have talked a little bit, and you've said something interesting. You've said these are really about campaign finance laws and how they can be used to chill free speech. Explain that a little bit.
Well, here's what happened. When Driehaus and his attorneys got wind that SBA List was going to put up these billboards, they did a couple things. They threatened to file suit against the billboard company for putting up a false, quote-unquote, ad, and they filed a complaint with the Ohio Election Commission under the statute they have there that prohibits false statements in campaign statements. So Ohio has this law that basically chills free speech because it purports to protect citizens who are voters by keeping false statements out of campaign rhetoric. On its face, that sounds like a noble cause. You know, we won't be hearing any lies, and you know, the voters will be voting just based on the truth, and the elections won't be tainted. All wonderful. But in reality, campaign finance laws, campaign speech control, are simply laws passed by incumbents who are already elected to protect themselves from the attacks of the people who are trying to get their jobs in future elections. So, and in this case was even worse because this sets up an appointed commission of people who are appointed by these incumbents to determine the truth or falsity of campaign ads. So it completely penalizes political speech, which is core speech protected by the First Amendment and what our founders put that clause in the First Amendment to protect.
Yeah. I'm so glad you're here today because the case that was before the Supreme Court is a little bit confusing, but we want to take a few minutes just to talk about what the Supreme Court ruled, why it's important. Now, from my understanding, it wound its way through the lower courts, ended up at the Supreme Court. Would you tell me what this ruling this week means?
Yes. Well, I have to back up. When the Ohio Election Commission got this complaint about the billboards, they made a finding of probable cause, that's the legal word for it, that SBA List had violated this statute in Ohio that prohibits false statements in campaign speech. What SBA List did was to try and challenge that statute in court. They started at the federal court in Ohio and lost because the trial court decided that procedurally they hadn't been injured yet, so you can't really bring a lawsuit until you've been injured. They said, that can't be right. Our First Amendment rights were chilled. We were injured. So they appealed to the Sixth Circuit, but the Sixth Circuit agreed with the lower court and said, no, you haven't been injured. So, you have no right to bring this suit. Well, they appealed, SBA List appealed from the Sixth Circuit to the Supreme Court of the United States, and this argument was really over whether SBA List had the right to be in court in the first place. And so now the Supreme Court says yes, unanimously, 9-0, SBA List has the right. They've been injured because their free speech has been chilled. They have the right to go back and have a local court, a trial court, decide whether that Ohio law violates the First Amendment. So we're going to start where we should have started in the first place in examining the First Amendment violation, but it took us all this time to get there.
I cannot tell you how glad I am that I have you to walk me through all of these things. They can be terribly confusing. I want you to talk a little bit about the free speech implications, because it really is a big win for free speech.
Well, it is. No one wants to see political speech, people who make political speeches or put billboards, no one wants to see them afraid to speak in the public square. And the other thing we don't want to see is somebody appointed as the decider of whether your statements are true or false. In a country founded on free speech, the remedy for speech you disagree with or speech you even think is false is not to censor that speech and prohibit it, but to provide more speech, better speech, accurate speech if that's what you believe. That is a value that promotes open elections, free elections, and no censorship.
So now as we head back into the lower courts, the Susan B. Anthony List will appear there, they will plead their case. What are their chances of being successful in that?
I think their chances are really good, because this is a classic violation of the First Amendment. There are all kinds of campaign laws out there, but to have somebody deciding whether your campaign ad is true or false and then starting a prosecution of you, which is what Ohio could have done, prosecute you for your speech, that is the antithesis of what the First Amendment stands for. So I'm certainly glad, and I do think that SBA List will be successful going back to the trial court.
Bruce, it is always good to have you here. Thank you for your expertise. Thanks for keeping track of all of these cases for us. You do a great job.
Hey, thanks for having me.
And thanks to all of you who have written to share your thoughts and encouragement. We love to hear from you. If you'd like to drop us a note, just go to mail@citizenlink.com. That's mail@citizenlink.com. And remember, please pray for our elected officials. They have a big job to do, and they could use our prayers and encouragement. And as always, stand tall and be heard.